Section 10002. None of the funds made available by this Act may be used to implement Executive Order 12473 of April 13, 1984, as amended by Executive Order 13669 of June 13, 2014, as those amendments apply to Section 405I of the Rules for Court-Martial.
Pursuant to the House Resolution 628, the gentlewoman from California and a member opposed each will control 5 minutes. The Chair recognizes the gentlewoman from California.
Thank you, Madam Chair. Last Friday, the President signed Executive Order 13669, which amended the manual for courts-martial. This order delivers a significant blow to an already broken military justice system that will further re-victimize service members brave enough to come forward and report that they have been sexually assaulted. Specifically, contained in this executive order is a provision that makes Military Rule of Evidence 412 admissible in Article 32 preliminary proceedings. This particular rule of evidence outlines when previous sexual history is admissible in court-martial proceedings and is currently applied to make all sorts of demeaning and irrelevant innuendos about a victim's previous sexual history admissible in court-martials. Now, mind you, rape shield laws have been passed by virtually every state in the Union, and the question I have is, why should service members be considered second-class citizens in this country? Shockingly, this order doubles down on this harmful rule and allows the sexual history to be admissible in preliminary hearings. What's even worse, under the order, the convening authority will be able to read and consider evidence deemed inadmissible by the Article 32 hearing. The military has clearly learned nothing from the Wilkerson case in Aviano, Italy. You may remember that General Franklin, the convening authority, justified overturning a court-martial jury that convicted Wilkerson of having sexually assaulted a woman. And even though he was convicted by 5 colonels, peers of his, the general was able to look at inadmissible evidence that the judge had ruled out of order and consider that in overturning the decision. This amendment will prohibit funds to implement the component of Executive Order 13369 to prevent this harmful and wrong-headed provision to go into effect. This order usurps and reverses the progress that is, in fact, this Congress has been making in reforming Article 32 proceedings, and I hope my colleagues will support the amendment. I reserve the balance of my time.
Gentlelady would yield.
I certainly will.
I appreciate her yielding. I appreciate her devotion to the issue and to the victims of these crimes, and rise in strong support of her position and appreciate not only her work but her offering the amendment today.
With gentlemen,
The gentlelady from California.
Will the gentlelady yield?
Yes, I do.
Now, I served on the Naval Academy Board for 5 years, and I know there's some issues in some people's mind as to whether this executive order either strengthens or weakens the case for rape shield, but I was appalled by what happened there, so I'm supportive of what you're doing. There may be some arguments people may have as to whether you're strengthening or weakening it, but your desire is to strengthen and make this unacceptable behavior go away.
That is correct.
And I'm supportive of that, and congratulate you on your efforts. I was on that Academy Board of Visitors for a number of years. The inability of the leadership of that academy, and to think that this midshipman had to go through this 30 hours, outrageous. So I commend you for what you've put forward here.
I thank the gentleman.
And yield back to you. Thank you.
Does anyone seek recognition in opposition to the amendment? Gentlelady from California is recognized.
Well, Madam Chair, with that, I will yield back the balance of my time, and I thank my colleagues for recognizing the importance of this amendment.
The gentlelady yields back. The question is on the amendment offered by the gentlewoman from California. Those in favor say aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment is agreed to. For what